We have one case on the docket scheduled for oral argument this afternoon, the case of Jose Oliva versus Bill Galvano et al. Jose Oliva and Bill Galvano et al. Versus Florida Wildlife Federation, Inc. and Florida Defenders of the Environment. Council, we have allocated 20 minutes per side for the oral argument this afternoon. I understand you have divided your time.
Yes, sir. I will be presenting for 10 minutes. I'll be followed by Mr. Uthmeyer on behalf of the executive for 5 minutes, and I'd like to reserve 5 minutes for rebuttal.
So noted, Madam Clerk. You may proceed, Counsel.
Thank you, Your Honor. This court should vacate the entry of summary judgment because the trial court imposed a drastic, unwritten limitation on expenditures from the LATF and then relied on that mistaken interpretation to invalidate 185 appropriations totaling more than $420 million. In concluding that the LATF funds may not be expended for restoration or management, except on lands purchased since July 1st, 2015, the trial court strayed from the constitutional text and gave no weight to the legislature's interpretation of the amendment. In fact, to prevail, the plaintiffs bore the burden to show that their interpretation was the only reasonable interpretation, that the appropriations were unconstitutional beyond any reasonable doubt, and that the legislature's contemporaneous interpretation of the constitutional amendment was manifestly erroneous. The interpretation that the trial court substituted for the legislature's interpretation is neither the only reasonable interpretation nor a supportable interpretation at all. The text of the constitutional amendment is broad. It contains no language suggesting that management or restoration or any of the other non-acquisition functions must be performed on lands purchased since July 1st of 2015. It was broad by design. The framers of the amendment anticipated that over the 20-year dedication of these funds, the needs of the state would evolve and would change. They also recognized that those needs are varied, that acquisition is not the sole need of the state, that there are drastic needs for restoration across the state in the Everglades, Lake Apopka, and elsewhere, our springs in North Florida, and they drafted this amendment to encompass all of those. They also recognized that a broader array of purposes to be authorized under the amendment would attract greater support. And in fact, the amendment passed with overwhelming support. We don't know whether it would have passed if it had been written the way that the trial court drafted its final judgment, because that was never presented to the voters, and nobody voted for that draft of the amendment. The trial court added words to the text that are not there. In its final order on page 7, it summarized the amendment as providing funds to acquire conservation lands and thereafter to improve, manage, and restore natural systems thereon and enhance public access or recreational enjoyment of those conservation lands. Those words, thereafter, thereon, and those, are not in the Constitution. Nobody voted for those words. Those words change the meaning of the Constitution as it is written.
If I could ask you a historical question. The Land Acquisition Trust Fund has been in existence for a while, correct?
Yes.
I don't recall exactly what year it was first enacted that there'd be this fund. Do you recall?
1963, Your Honor.
Okay, so it's been out there for 50 plus years.
Yes.
Is there anything in the record here that would suggest to us that the funds that have been put into that trust fund historically have been just earmarked for acquisition, or have they been used for restoration, maintenance, and so forth, preservation of conservation lands?
What we do have in the record, Your Honor, is the statute itself that authorized funds for two specific purposes. So when it was first enacted in 1963, the LATF was really designed to kickstart the state's development of its state park system and its state forest system. So it was designed for outdoor recreational purposes primarily, and secondarily conservation. It authorized two specific things. One was acquisition of these recreational lands, and number two was the construction of capital improvements and facilities. That's it. Those are the two things that were authorized. Sometimes from year to year, the legislature would make one-year changes to that, but those were the two pillars of the statute. So the statute was different from what the constitutional amendment authorizes because it was narrower. It didn't authorize restoration of natural systems. It didn't authorize management. It didn't authorize improvement of water areas. It didn't list the various properties from wildlife management areas to historic or geologic sites. So the purpose of the original LATF was more specific, and presumably the funds were expended for those purposes, although I don't believe there's anything in the record regarding the specific expenditures that were made under the former LATF. Yes.
So the constitutional amendment we're looking at today expanded the scope of how these LATF funds could be spent.
It includes a broader array of purposes that are authorized. Yes, Your Honor.
And is that an unbroken line between 63, I think you said, and the constitutional amendment that there really wasn't any sort of change in the functional of the uses of, or the functions of the uses of the funds?
There were occasional one-year amendments to the LATF statute. Beginning in 1996, the legislature made amendments to the statute to conform to appropriations that were being made in those particular fiscal years. So there were some fiscal years in which the legislature wanted to spend money on purposes outside of the two specific authorized purposes. They would make a one-year change to the statute to authorize that to be consistent with the General Appropriations Act. But the two main pillars of the LATF statute remained consistent, and that was the focus of that statute until this amendment was adopted. And I think what's telling is that the amendment has markedly different language from the old LATF statute. So when the two are put side by side, it's not the same language. Parts of it are the same, but there are significant differences as well.
But even in the prior version of the statute, they could construct, improve, enlarge, extend, operate, and maintain capital improvements and facilities.
Yes.
So it wasn't exclusively, even in the more narrow scope, exclusively the acquisition of land, right?
Correct. Even in the narrower scope, it did authorize some activities with respect to capital improvements and facilities. It was never limited exclusively to acquisition.
Well, what are we to make of the advisory opinion that approved putting the amendment on the ballot, where the Supreme Court said unanimously the proposed amendment does not seek to create or alter the purpose or management of the Land Acquisition Trust Fund?
Right.
What does that mean?
I think that means that this trust fund satisfies a single subject requirement, which is what the court was looking at in that case, because it's going to continue to serve environmental and conservation purposes. So it's not being changed into a trust fund that will fund road construction or that will fund health care or education or something else. Its fundamental purpose will remain the same. Now, I don't think that what the court meant by that is that we will continue to look to the old statute with its authorized purposes instead of subsection B in the new constitutional amendment to determine what is authorized. I mean, clearly the old statute does not trump a new constitutional provision that has different language in it. So I don't think that what the court meant there is, even though restoration of natural systems, for example, is in the constitutional amendment, that it's not an authorized purpose because it wasn't included in the old statute. That would simply be an unreasonable reading of what the Florida Supreme Court was saying. I think what it was saying there is it continues to serve conservation purposes. Certainly there's some adjustment made to the specific purposes within that more general purpose. But I don't think what the court was saying is, let's continue to look to the statute, let's simply ignore the constitutional text in subsection B. And the interpretation that we have advanced consistently has been consistent with what the sponsor has said throughout the campaign to the Financial Impact Estimating Conference, which prepared a financial impact statement for the ballot, which the voters were invited to rely upon.
You would agree that if we find the language to be unambiguous, though, all of those extrinsic matters are not appropriate for our consideration?
Yes, Your Honor. If it is unambiguous, it's unnecessary to look to those other to those extrinsic sources. And as to the specific point, and we're not asking for an omnibus interpretation of the constitutional amendment in this case. The specific question before this court is whether the time limitation, the acquisition date limitation that the trial court imposed is supported by the text. And as to that specific point, the text is unambiguous because there's nothing in the text to support that. So yes, Your Honor.
If we agree with you with regard to the temporal limitation, do we need to address the state ownership of the land issue? That I think at least FWF raises that in their briefs.
I don't think it's necessary to address that because I don't think that there was any evidence to suggest that even if that limitation were applicable, that these appropriations would be unconstitutional. So really the basis of the trial court's holding is its conclusion that there was an acquisition date limitation. But at the same time, the state ownership limitation is implicit in that acquisition date requirement because
well, they would have had to buy it
they would have had to
improve it. Sure,
correct, Your Honor. Yes, but I don't think that in order to reverse this, the summary judgment and vacate the court's entry of judgment, it would be necessary to reach the state ownership limitation.
The trial court did not find the statute in question ambiguous, did it?
No, the trial court believed that it was unambiguous and believed that that it unambiguously imposed an acquisition date limitation. In fact, if the trial court had found it to be ambiguous, our position would be that at that point, the court would have to agree with our interpretation and uphold the appropriations, because if there are two reasonable interpretations, then they haven't carried their burden of proof or their burden of persuasion to show that these appropriations are invalid beyond any reasonable doubt. If there are two reasonable interpretations, then there remains a reasonable doubt at the very least.
And what is our standard of review in this case?
I'm sorry?
And what is our standard of review?
Your standard of review is de novo on summary judgment, all of the issues that were raised in this case, on summary judgment, on the interpretation of the constitutional provision. The standard is de novo. I think it's important, Your Honor, to continue to apply the plain words of the Constitution, because the legislature, and as you'll hear, the executive branch, has a duty to implement this, and it must be able to rely on the plain language of the Constitution. In this case, as we know, there was a long history in which the sponsor asserted that there was a wide array of purposes that this would serve. The FIAC agreed with that. It put a financial impact statement on the ballot that would have been misleading if the plaintiff's interpretation were correct. And it can't be that 3.5 years into the litigation and the life of this amendment, the plaintiffs realized that there's a different interpretation, and then we all change course. So we ask the court to uphold the plain language of the amendment and reverse, and I'll yield to Mr. Uthmeyer.
Thank you, counsel.
May it please the court, my name is James Uthmeyer, here, Deputy General Counsel on behalf of the Governor, representing the executive agencies. Your Honors, the executive would like to reaffirm two key points today. The government, in executing the law and the will of the voters, must be able to rely on the text. And second, the trial court's order, if affirmed, would undermine some of the state's most significant environmental restoration efforts. The government must be able...
Counsel, what will be the effect of the trial court's ruling on Everglades restoration, if any?
I'm sorry, I didn't hear you, Your
What will
Honor.
be the effect of the trial court's ruling on Everglades restoration, if any?
It would be very significant, Your Honor. Over $200 million of LATF funds are used on Everglades restoration, and indeed over 95% of the state-owned lands on the Everglades were acquired prior to 2015. Accordingly, everything that the voters were presented with when Amendment 1 was advertised, it was advertised as an Everglades restoration bill, as a clean water bill. All of that would be frustrated, and the legislature would have to find some other way to raise revenues to cover those costs.
But weren't there funds being expended on those the Everglades beforehand, previous years?
In previous years, yes, Your Honor. However, what's clear here is that the voters wanted to create a floor or a baseline, a pot of money that would be dedicated to funds like this. For example, the Department of Environmental Protection's annual budget this year is about $350 million. LATF is more than double that. So while the legislature could find other means and use other means to pay for these activities, here this is a dedicated pot set aside that was expected to grow more and more each year.
There's additional funds beyond those that had been appropriated in previous years.
These are additional funds, yes, Your Honor. In addition, when the voters were advertised on Amendment 1, significant effort went into springs and water cleanliness restoration. Again, the majority of the waters in the state are required by the state prior to 2015, so these purposes would be frustrated.
So in practical effect, if the legislature and the governor and so forth decide, okay, all these new monies are all going to go back for the activities we used to do in the past, and we're going to use those other funds for other purposes. I mean, I guess what I'm getting at is, couldn't they decide to just use all these new funds for, I'll call them old activities, and none of them would be used for other than those purposes?
Well, I think the language is very clear that there's a broad set of activities. While some of the funding could be used for previous activities, Some would now be dedicated towards other things that were not included in the language
I guess
before.
maybe I phrase it differently. Could it be the case that in the end, none of the funds are used for new acquisitions or new restoration projects?
Well, I certainly think that acquisition is a key element here. It's one of the 10 objects listed in the text. It's the first of the object. I don't see a situation where none of the funds will go towards newly acquired
But
land.
that's theoretically possible.
It is theoretically possible, but again, I think we have to look at the context and the parameters here. So with that, I'll yield back or I'll reserve the rest of the time for rebuttal and just reaffirm that the executive asks that the trial court be overruled. Any ruling to the contrary would significantly undermine the state's significant environmental purposes. Thank you.
Thank you, counsel.
Your Honors, may it please the court, I'd like to divide our time, 10 minutes for me and 10 minutes for FWF. May we do that?
So noted. You may proceed, counsel.
May it please the court, I am Joe Little, and I represent Florida Defenders of the Environment and the named individual members thereof. This court has before it, and we respectfully request this court should affirm the final judgment before it. This court has got a dramatic determination to make. Did the voters, in fact, intend, when voting, to approve the purchase of new lands, or did they not? The position that the court below took and that we support is that the provision is intended to provide for the acquisition of new conservation lands and the improvement and management of lands so acquired.
But Professor Little, at the very start of B1, it talks about finance and refinance, the acquisition and improvement of land, water areas, related property interest. It doesn't say of such lands or lands thereof or therefore such lands acquired. So you seem to be putting a limitation that's not textually supported. I understand that perhaps maybe that was the voters or some voters' intent. We've got amicus briefs on various sides of that, but the plain language when it talks about the acquisition and improvement of land has got to mean something, right?
Well, Your Honor, I think we have to, first of all, look at the title of this provision, Land Acquisition Trust Fund, and the ballot title, Dedicated Funds to the Acquisition and Improvement of Lands. This is what the voters were looking at. And I think that was what the voters intended to do when they did this. Now, I'd like to take a minute, if I may, and digress to the temporal question that was raised earlier. And if you look at Article 10, Section 28, it states, beginning in A, effective on July 1st of the year following passage of this amendment by the voters, and for a period of 20 years thereafter, 20 years after that effective date, the Land Acquisition Trust Fund shall receive the funds. That's the starting point. That is the temporal starting point for the activities authorized and required by this provision. It's not reaching back into the past, but it's telling us these monies are used for the future, starting on this date and continuing for the next 20 years. And Your Honor, Judge Macker, going to your question, the record supports no finding at all that the legislature has spent a single penny on the acquisition of new lands up through the time this provision was litigated in the court below. So the question is, in fact, do we have a clear meaning of this provision that is to acquire new lands and to improve and manage those lands so acquired? Or is it that the provision is to permit the legislature to do anything it wants to with the money?
Well, it would still be constrained for these uses under the statute. I mean, the lottery problem that I'm aware of, the lottery money going to things that the voters perhaps didn't think they approved, that's not present here, right? There are at least some limitations on how the money can be used, and it can't be commingled with the general revenue fund.
Your Honor, there's almost no limit on how the money could be spent. Most of the lands owned by the state of Florida, including state forest and state parks, are conservation lands. And under the legislature's reading and under the practice, this money can be diverted to managing those operations, not acquiring any new lands at all.
Can I ask you about the beaches and shores? The state already owns the beaches, at least up to what the mean erosion mark or high water mark, I forget which. But if it's only for newly acquired beaches, the state can't buy any new beaches because they already own them. So how would this apply to beaches and shores, which are specifically in B1?
Well, I think the state owns up to, what, the median high water line? The beach continues up to the high water line and beyond to the dunes. All of that may need to be purchased and improved in order to protect the interest of the people of Florida in this matter. So the question is quite clear. Did the voters intend something here? And let me talk about the Everglades for a moment. We have two provisions in the Constitution having to do with the Everglades. Article 2, Section 7, subsection B, in fact, provides that the polluters are primarily responsible for cleaning up the Everglades. And the legislature has never taken the action that it has the power to take to make the polluters provide the money to clean up the Everglades. You may remember when that provision was adopted, I think it was 1996, there was another provision on the ballot at the same time connected with it to impose a sugar tax so that the consumers of sugar would be the ones that would provide the money to clean up the Everglades. That failed, and the Supreme Court decided, if you look at the 1996 case that's cited in our briefs, that the voters didn't want the consumers to pay for that. They wanted the Everglades polluters to pay for that. The legislature's got plenty of money, if it wishes to, devote it to cleaning up the Everglades. This is not the only money that's available to the Everglades. It's the only money that is dedicated to purchasing new conservation lands, which is the greatest need that we have in the state of Florida in regard to environmental matters. At least that would be the position of FDE.
Professor, on B1, why doesn't together with just mean and? That seems to be the common usage as one of the amicus briefs.
Even if it does mean just and, Your Honor, it refers back to the provisions that come before it. It's a package, if you like. So we're going to acquire conservation lands, and I think the way I would read this is that what we have next in the next 8 items are examples of conservation lands we want to make sure are considered in acquisition. And then the last provision, and we want to manage and improve those lands so acquired. That's a plain reading of that provision, it would seem to me, Your Honor, and I think that's the way Judge Dodson read it.
Your client wasn't the sponsor of the amendment, right? Your client wasn't the sponsor of the amendment. Who's the sponsor of the amendment?
No, my client was not the sponsor of the amendment.
Okay, we don't have the sponsor in the litigation.
We don't have the sponsor in the litigation. The sponsors, I think, have filed amicus briefs in this case. Let me mention something about sponsors. And I'll mention a statement that Lord Halsbury made, Lord Halsbury of Halsbury's Laws of England, in a 2003 case, not 2003, 1992 case. And you can find this in 1902 appeals cases. I think it's 247. Lord Halsbury said, the worst person to construe or interpret, he was referring to a statute, of course, a statutory provision, is the drafter. Because the drafter had something in mind that he wanted to accomplish, and he may not have accomplished it in the words that he used. And he cannot later disassociate himself from what he thought he did with what he actually did. And that's a very good thing here.
So we're to figure out what the drafter thought he did as opposed to the actual words the drafter used?
Exactly. That's exactly right. We have to look at the words the drafter actually used and what the voters thought the drafter was trying to achieve. And Your Honors, I respectfully submit that everything here in the provision and in the background of it points to the fact that the voters thought they were providing money to purchase new lands. Thank you, Your Honors.
May it please the court, I'm David Guest representing the other appellees here. I'm sorry. Those clients are Florida Wildlife Federation, Manly Fuller, Sierra Club, St. John's Riverkeeper, and Environmental Confederation of Southwest Florida. The advisory opinion had to decide whether the summary was accurate and whether it was a single subject, and to do that, it had to interpret the amendment. And it did interpret it, and it said that the amendment accomplishes but one thing, which is to fix the amount of revenue going to an existing trust fund with no change in purpose or management. The question in this case is, do these appropriations fall outside the interpretation provided to the Supreme Court that was the last word that the people of Florida heard before they voted? They found that the summary was accurate, and that has to control the construction of this thing. Now, the thing that's revealing that happened here was that the legislature appropriated hundreds of millions of dollars for things that the LATF had never been used for, ever before, that fell completely outside its purpose, and they made each of those appropriations contingent on passage of implementing legislation that removed from the LATF statute the purpose that had been there for 50 years. And that purpose was to acquire land and water areas and resources related to that.
You referred to the ballot summary, and I guess we only look at that if there's some ambiguity. But the ballot summary says the funds of the LATF to acquire, in addition to that, restore, improve, and manage conservation lands, and nothing there limits that to the lands so acquired. So it would seem like even if we referred to the ballot summary, the state would still be permitted to use these things other than just acquiring land.
Yes, let me be clear here. We did not argue in the trial court for the temporal restriction. We argued only that it could be used for conservation lands only, and then for conservation purposes. So it was a subset.
The conservation lands argument, that stems from the very last little clause of B1, right?
Yes.
The of conservation lands.
Right.
If that, in your contention, as I understand it, is that applies to management, restoration of natural systems, and enhancement, all three of the separate clauses in that last kind of extended clause, right?
Yes, exactly, and here's why, is that you certainly could construe it so that the modifier only modifies modifiers on conservation lands, so it applies to the last one. But the summary says funds the Land Acquisition Trust Fund to acquire restore, improve, and manage conservation lands, including. So the usage in the summary means that the conservation lands limiter applies to all of those, and the Supreme Court found that it was accurate. So I don't think that that argument is available. That the court approved it is accurate, and the summary leaves absolutely no doubt that this whole thing applies only to conservation lands.
As to the first clause of the provision, it says to finance or refinance the acquisition and improvement of the land, water areas, and related property interests. How do you construe the term refinance in this context?
Well, the reality, I think, is that this comes from another provision in the Constitution which actually had refinancing of land. Let me give you a broader picture that hasn't been talked about here. What this fund was actually used for, mainly beginning in the 70s, was to finance land acquisition projects under Chapter 259, the Land Conservation Act. So what you did was you had the funds would be bonded through the Land Acquisition Trust Fund and paid into the Preservation 2000 Trust Fund to buy land, or into the Florida Forever Trust Fund, its successor, to buy land and also to restore it in the Florida Forever statute. So I think that the refinancing refers to the bonding process, in fact. I think that's what it means.
But if only conservation lands are involved, why would the state finance or refinance a conservation easement on its own conservation lands?
Well, I don't know that it would, I don't think it would probably do that. But I think what refinancing, I think it has to refer to the practices of the fund of refinancing land purchases. I will tell you honestly, the Land Acquisition Trust Fund use of refinancing was limited to bonding. That's what I can tell you. Other than that, I don't have an explanation. But I don't think it bears on this. And let me answer a couple of questions here. Are these things that the fund was always used for in the past? Restoration was, and the answer is yes. You had, restoration can be an improvement. Restoration can be bonded. Big environmental restoration projects can be bonded, and you can only bond capital projects. So that's part of that. Another piece of it is that it's also management. There's two pieces to restoration is management, and specifically in 031, 335.031, the one the section in the statute that's got the Land Acquisition Trust Fund in it, it authorizes transferring money to agencies for management purposes. So that's how you get to there. And another way you get to there is that Chapter 259 was what was being financed with the Land Acquisition Trust Fund, and it was used for restoration projects too. So that's the big answer to that thing. Now let me turn to, so what I'm saying is all the consequences that people seem so deeply concerned about are really not present in the situation where you're limited to existing conservation land. That's all. And I don't think we hear much argument of that, except that let me get down to what the core of this problem is. The legislature, you heard them say it, this is an all-purpose environmental slush fund that can be used for everything. And we say, no, it's the traditional Land Acquisition Trust Fund, like the court said it was, to acquire, improve, and manage, restore land. That's the basic controversy. And it's captured, this controversy is captured by one of the appropriations that the judge found invalid, and it's number 1533 in the statute, which is 15-232. 1533 is an appropriation to the Department of Environmental Protection, and it pays for each and every salaried position in the IT department. DEP does mining wastes, hazardous wastes, air pollution, a variety of different regulatory things, but every single salaried employee in the IT department was paid from the Land Acquisition Trust Fund. That captures the dispute here. They say it's for environmental purposes generally. We say, no, it's only for acquiring land and also for taking existing conservation land and improving it, managing, restoring it, enhancing public access. That's the controversy. In answer to the earlier question about, well, you know, we don't have to get to paragraph 2, yes, you do. This is a declaratory judgment. It raises the question about, is this an all-purpose environmental fund, or is this the traditional land acquisition trust fund? So, Everglades. In 2014, without land acquisition trust fund money, the Everglades got $299 million from other sources. Most, perhaps, I don't know, maybe even all of the Everglades are conservation lands. Certainly, the state conservation lands are the vast majority of that. And those are conservation lands. They are managed as conservation lands. They're conservation land units. That means the impact on the Everglades is not clear at all, that this actually has an adverse effect on that. If you add the $300 million from other sources, you've got lots of money to do that with. You have any questions I can, yeah. Okay, thank you.
Thank you. May it please the court. One thing we did not hear in the last 20 minutes is any reference to any text in the Constitution that would support the trial court's judgment. The plaintiffs have pointed to no language that would support a theory that prioritizes acquisition and then makes management and the other non-acquisition functions dependent on a prior acquisition. That we haven't seen. We heard about the intent of the voters, but we haven't seen any evidence as to what that intent was. The voters did not vote on a constitutional amendment that was drafted to fund only land acquisition, and we don't know how they would have voted on such an amendment. We have been referred to the ballot summary, but the ballot summary refers to acquisition, restoration, improvement, and management without any suggestion that the acquisition must come first. In the trial court's final judgment, the court summarized the ballot summary by saying that according to the ballot summary, lands can be acquired and then restored, improved, and managed, but the ballot summary doesn't say and then. Again, those words were added and changed the meaning. We were referred to historical antecedents in the Florida Constitution and the Everglades provisions in the Constitution. Plaintiffs send mixed messages on historical antecedents. When they find a constitutional provision that predates this constitutional amendment that is a land acquisition provision, they say that that foreshadows this amendment and informs the meaning of this amendment. When they find a prior interpretation or prior provision relating to Everglades restoration, then they say the voters have already taken care of Everglades restoration, so obviously this amendment wasn't designed to do that. They can't have it both ways.
If I could ask you,
Yes.
they mentioned an appropriation, they said that which shows the two conflicting sides here. I mean, it could be that there's some appropriations that are outside the scope of the amendment, correct? I mean,
That's why we were ready to have a trial. Yes, Your Honor, and that's what a trial was designed to do. And the way to determine that is not to rewrite the amendment and to impose limitations that weren't there, but to have a trial and follow the text of the amendment. And if the trial court applies the text of the amendment as written and determines that some of the appropriations are outside the scope, then that might be the result the trial court reaches. But the right answer is not to point to an appropriation and then infer from that we need to rewrite the amendment to prioritize acquisition because we need to limit what the voters have approved. That's not the right approach. These plaintiffs are concerned about acquisition only, but other environmental groups clearly were concerned about other things, including Everglades restoration. We do not view this as an all-purpose trust fund. The choice here is not between an all-purpose trust fund and a properly limited trust fund. The choice here is between following the text of the Constitution as written and applying it as written, or devising new limitations that are not in the text in order to limit this to an acquisition program that the voters didn't approve and which is unprecedented in its scope and magnitude.
I understand your argument about the temporal nature and perhaps misunderstanding of the trial court that goes to the paragraphs 1 and 2 on page 7 of what the trial judge ordered and adjudged. But what about the paragraphs 3 and 4 about the commingling, no appropriation may be made to any other entity and agencies expending money from the Land Acquisition Trust Fund? must track the expenditures. Is there a problem with that we need to address?
There is, Your Honor, yes. The commingling argument was never pleaded. It was never raised except in the FDE's motion for summary judgment. We immediately objected to the adjudication of that claim because it hadn't been pleaded, and then the trial court went ahead and decided it anyway. So it was not before the court. And there was conflicting evidence, not even conflicting evidence. There was evidence only on our side at the summary judgment stage. There was a declaration from Joanne Lasnoff, a staff director in the Florida House of Representatives, stating that funds were not commingled. And so on summary judgment, certainly, even if it had been pleaded, that would not be appropriate to decide. Regarding the tracking of funds and the dictating of language for the appropriations bills, that was not relief that any party ever requested in a pleading or in their dispositive motions. So that was not appropriate to be granted here. It was not argued at the hearing, and so that should be reversed as well. We never had an opportunity to be heard on that.
Counsel, you raised 4 issues on appeal. Assume for the sake of argument that you prevail on the first issue. Would that not moot the second issue, the commingling funds issue, as well as issues of the temporary injunction, the third issue on appeal?
I don't think it would moot it, Your Honor, because I think if this court reverses and determines that the acquisition date limitation does not apply, there would still be a finding by the trial court that funds were improperly commingled, and there would still be a direction to the legislature to draft its appropriations bills in a certain way, and those would still have to be addressed. So those are in the final judgment, and I don't think that the acquisition date issue would resolve those issues. Finally, I would just say on the conservation lands issue, again, the text is the guide. Conservation lands is used twice in very specific circumstances in the text. It doesn't cut across the entire amendment. If that's what the drafters had intended, that's what they would have said. And we ask the court to follow the text of the amendment and vacate the summary judgment.
Thank you, counsels, for your respective arguments this afternoon. This concludes our arguments for this afternoon, and we stand in recess.
All rise.